which eventually established the core establishment of cyber jurisprudence. Cyber jurisprudence is a practical knowledge. It doesn't depend on theoretical analysis of legal precedents and legal texts. It follows up courts' judgments and how judges applied laws in cyberspace relevant litigations. As we know, cyberspace suffers from legal vacuum because not all incidents that occur in cyberspace are regulated and governed by a given law. In addition, cyberspace proves to be an unbounded and a borderless also sphere of interactions between humans. So its incidence exceeds beyond one jurisdiction limits and involves other jurisdictions. So we will see several jurisdictions involved in one cyber incident. In addition to the state of the fragmentation between the legal fragmentation between states in regulating cyberspace incidents, each state has its own laws and own regulations regarding cyberspace incidents. This creates a fragmentation, creating eventually a blind spots that cyber criminals can use easily and can exploit to breach into internet users and inflict damage into internet users, whether they were humans, individuals, or states or other corporations. From this lecture, we will learn, and I hope to learn that I can teach you how to put a grasp on cyber jurisprudence as an emerging concept, to identify and classify digital era case laws and judicial conflicts before courts related to cyberspace, applying FIRAC framework to analyze judgments. And this is a practical aspect of this lecture. Evaluate court interpretations of digital evidence, privacy, jurisdiction, inter alia other legal issues raised by a single conflict. Reflect on evolving legal principles in cyberspace. First of all, this question is the major contribution of this lecture, the major production. Should courts invent cyber legal norms? And I want you to answer not now. We will answer together after the end of this lecture. So this is the main outcome of this lecture, to know that any court can invent a legal norm to tackle an unorganized cyber legal incident. As I said, not all cyber incidents are regulated, and legal vacuum prevails in cyberspace. So cyber jurisprudence depends mainly on the court's efforts, and this is from a judicial perspective, honestly. So should courts invent cyber legal norms? This is the main outcome, and we will answer it together after I finish this presentation. It will be the discussion of this lecture. First of all, what is cyber jurisprudence? Cyber jurisprudence is a branch of legal science focusing on studying the interpretation and application of legal rules in cyberspace, how courts interpret existing legal texts and apply them to settle conflicts arising in cyberspace between humans due to their interactions therein. It enhances legal governance of cyberspace by maintaining the applicability of laws, because its contribution to eradicating the legal vacuum potentialities by interpretation and exceeding the applicability of existing legal rules to cyberspace. As a consequence, the legal vacuum will be eradicated in cyberspace. It also crystallizes the technological impacts on judicial methodologies. We will see through studying case laws how the judicial function is changed, have become changed and affected by the technological advancements occurring in cyberspace and their impacts on human interactions therein. Cyber jurisprudence focusing mainly on defining the cyber dimension by understanding how human interactions reduced to binary codes and processed by servers, creating a cyber characteristic for societal disputes. Since judicial conflict is concretely a societal dispute between two members of a society, disregarding the fact that this society is belongs to one nation or humanity as a cosmopolitan society, cyber jurisprudence focusing on extracting the cyber dimension of these interactions, the conflicts arising with a cyber dimension, the cyber element, and I will explain this later on in this lecture. As a concept, cyber jurisprudence focusing on exploring the infusion of codes and algorithms into classical jurisprudential tools such as deduction and inference. This means, to simplify, cyber jurisprudence focus on extracting the technological impacts of transferring human interactions from direct one in the real world, from a human to human, to a codic ones, depending on codes and algorithms, and like what happens in cyberspace. This creating a huge impact on how judges apply law, how judges think about law. This is called the jurisprudential impacts of technology. Also, cyber jurisprudence addresses the, the issue of legal vacuum prevailed in cyberspace by illustrating how judicial innovation prevents a denial of justice. Denial of justice is a term that means that an incident cannot be settled judicially, and this is an undesired state of the art. And in Egypt, denial of justice is considered a crime. It is a crime in Egypt called denial of justice, and it is only committed by a judge. It is not committed by any citizen, and it is committed when the judge says this incident cannot be settled judicially. There is no law or there is no rule controlling this incident. So judges are compelled to innovate interpretations of existing law to cover the incident, to prevent this denial of justice, and thus to achieve justice by settling this in this conflict. When traditional laws proves stand still against rapidly evolving cyber events, judges here intervene to innovate interpretations of existing legal rules to govern this conflict. As I said, to prevent denial of justice. Cyber jurisprudence has proven to be an emerging branch of legal science, independent from cyber law. Cyber law is a general one, and cyber jurisprudence is a specialized branch on focusing on how courts mainly interpret and apply traditional legal principles to disputes arising in cyberspace. So, cyber jurisprudence here focusing on the law, the court's endeavor, judicial endeavor to eradicate legal vacuum in cyberspace, and it doesn't include by virtue legislature endeavors to govern cyberspace legally. It focuses on the court's approach, the judicial approach is here. Cyber jurisprudence studies the adaptable and flexible judicial approach utilized by judges to tackle technological challenges by utilizing their innovative interpretations of existing legal rules. And this is the core of cyber jurisprudence. So it is emerging branch, independent from cyber law because of its particularity, focusing on the judicial endeavors to eradicate legal vacuum in cyberspace by using innovative jurisprudential tools like interpretation, deduction, and interference. So it proves that judicial methods are adaptable and flexible, and they can tackle technological challenges without waiting the legislator to intervene by issuing an ad hoc legislation. Because in all states in the world, the legislative process takes time. Unlike one judgment does not take the same time required for one legislation. So this is the core contribution of courts to cyber jurisprudence. What are the key concepts of cyber jurisprudence? And this is a brief of them. First of all, innovation. Judicial enhancing of justice in cyberspace by applying and utilizing innovative judicial interpretations of existing laws and legal rules. Innovation, it reflects the judicial endeavors in addressing the unprecedented pace and complexity of digital conflicts. As I said, cyberspace technologies is evolving rapidly and outpaces the legislators endeavors to enact an ad hoc legislation. So judges intervene here by a rapid tool, which is the judgment, the reasoning of the judgment in particular. It takes less time than issuing a legislation, and this proves a temporary and practical solution to settle a single dispute arising in cyberspace, which might be not governed by an ad hoc legal rule. Establishing cyber jurisprudence globally depends on case laws analysis, because court rulings highlight the judicial application of legal norms in cyber disputes and emphasize the evolving nature of judicial reasoning in cyberspace, which permits courts to tackle the rapidly evolving technological impacts of cyberspace on human interactions and the nature of interhuman conflicts. The third is technological integration. This is cyber jurisprudence studies an integrated judicial process based in technology. Judges here are compelled to combine their judicial abilities and skills manifested in the judgment reasoning. The reasoning must reflect how the judge has tackled the technological challenge imposed by the cyber incident, and how it integrated existing traditional legal rules into the context of the cyber incident until it reached the judgment conclusion, and it all is reflected within the court's judgment. Sustaining the applicability and functionality of laws, as I said earlier, because the core concept of courts in cyber jurisprudence is maintaining the applicability of laws and eradicating legal vacuum in cyberspace. How? By innovating adequate and appropriate, innovative also, legal interpretations of traditional laws and exceed them beyond the limits of traditional logic and adapt them to the technological nature of the cyber incident. This is the second part of our lecture. The first one we took a glimpse on cyber jurisprudence. What is cyber jurisprudence as an emerging branch of legal knowledge, and what constitutes its main concepts and main pillars. And it was a brief, in fact, it wasn't. It was a simplified, and this is the most simplification I could provide it. In fact, in this part, cyber case laws, concept and analysis, we will shed light on what constitutes a cyber case law among judicial conflicts, from what is its concept and how to analyze them to extract the norm included within their judgments. These norms are the bricks of cyber jurisprudence. When you extract a norm from a judgment, this norm reflects how the judge thinks, how the judge tackle the technological challenge by saying, I have a cyber incident, but we don't have a governing legal rule. So I will look into our traditional existing legal rules and I will reinterpret them and reconceptualize their terminologies and structure into the conflict in a manner adapting to the technological theme of the conflict. This is called the norm, the judicial norm, and in other words, the cyber judicial norm. And we will talk about it soon. What is cyber case law? Sometimes in scholarships call them cyber dispute or cyber litigation, cyber lawsuit or cyber judicial conflicts. All those terminologies reflects one thing, which is the judicial conflicts before a court arising from a cyberspace incident or a cyberspace relation. Conflicts that arise from the use of technology and human interactions in the digital realm. Their uniqueness and why we said that there is an independent category called cyber case laws comes from their cyber element. The difference between them and other case laws, they all carry a cyber element and reflecting that their root and the fact that they are rooted in cyberspace and they didn't come from the real world. This is called the cyber element. So, to distinguish a cyber case law from another one, a real world case law or a traditional case law, you must always search for the cyber element. This cyber element might not appear from the beginning of the conflict. By the way, it might appear later on. And I will give you examples later on because it happens, and it happens in particularly in Egypt here. They are characterized by their technological nature and virtual structure, meaning that they don't have a physical manifestation. However, they bear a significant real-world consequences. So we are tackling here a very unique item, a virtual structure that is tangible, that doesn't exist in the real world. However, it bear a significant and sometimes severe real world impacts. Their unique feature also is their infinite evolvement due to the continuing technological developments of cyberspace technology. In the In the last decade of the 20th century, internet was only a dial-up between a internet user to a server, and he or she only contacted another one in another part of the world directly and very simply. It was a real human to a real human contact. Now we have the AI. A human may contact an AI, and can establish contact with an AI, and not in the real world, in a VR world, in a virtual reality, which is very independent from the basic human reality in the real world and his reality on the internet. So we have a third degrees of reality. So, and this is a direct impact of the rapidly evolving technological developments, and these developments are infinite. Technology always develops, always evolves. It doesn't stop. It's like a tree that each second grows new stems and throws new fruits each minute, each moment, in fact. And this is a very challenging reality of cyber case laws and cyber disputes that incentivize the court's motivations to intervene, to invent norms and govern the disputes until the legislators intervene from his part by issuing an ad hoc legislation. The dispute, although the cyber dispute itself is ongoingly generative, with unbounded and unprecedented impacts. I mean, when a cyber crime occurs, sometimes the effects of the act doesn't stop and doesn't end when the act itself ends. Sometimes the act ends and the attack occurs, but its impacts are still going and appearing and inflicting damage on its victims and granting gains to the cyber criminal. And although it is not limited to cyber crimes, it extends also to cyber civil disputes and cyber family disputes also. So we are handling a dispute that is ongoingly generative of impacts, and these impacts are unbounded and unprecedented. Each dispute can generate very new impacts and very limitless. So the court finds itself discussing a new nature of conflicts and they might not find any precedents that would help to settle it. So here comes the role of the judicial innovation and the single judicial skills of each judge per se to tackle and to face this state of the art. What are challenges imposed by cyber case laws? They are ultimately technical due to their technological core and impacts, unprecedentedly novel. So they prevent creating stable jurisprudence and provide stable precedents that help the judge to settle the dispute easily. Also, legal frameworks globally suffers from fragmentation because each state has regulated cyber incidents according to their national backgrounds, cultural, legal, religious background, and the interests that a state wanna achieve from regulating cyberspace incidents. So the whole scene suffers from fragmentation, a fragmentation status, and particularly in cyberspace. What is legal? What is legally in a state like Pakistan or Egypt with an Islamic framework? What is not legal therein in those countries might be legal in other countries in Europe. So this is state called a fragmentation of legal frameworks. The cyber element implies developing suitable flexible analysis mechanism under an innovative judicial supervision by applying innovative interpretations of existing legal law through reinterpretation and reconceptualization of them. This is not unlimited mechanism. This mechanism must be supervised judicially, even even by Supreme Courts or even by the litigation parties themselves. They can seek to annul a judgment and annul the judge's courts, the judge's reasoning that created the norm, and this is a sort of judicial supervision. It is not directly the judicial one. It is non-direct judicial supervision because it is conducted by a party of the judicial conflict. They are transnational and not limited to a single jurisdiction, as I said earlier, and put this fact along with the fragmentation fact, the utter result of a prevailed legal vacuum in cyberspace and the notable blind spots therein. Typology of cyber case laws. The most common, as all we say, and because it is the most suffered in the contemporary world, cyber crimes, because they are the most suffered, and this category is the most beneficial for criminals and the easiest one. Also, we have civil disputes in cyberspace like defamation, digital contracts, torts, injury in facts, cyber intellectual property, copyright infringements, and domain disputes. And nowadays we have the patentability of AI generated artworks also, and they are considered cyber case laws. Cyber regulatory like data protection, surveillance, net neutrality, political like cyber espionage and warfare, and also AI hybrid threats. This is an emerging branch nowadays of this of cyber case laws. So, the typologies of cyber case laws or cyber conflicts doesn't only does not include only cyber crimes. Cyber crimes are the most famous because they are the most occurring. No, they extend to civil relations, intellectual property, and it also family relations when someone marries another through cyberspace, and it happens. To analyze a cyber case law, what proves best to achieve the objectives of this mission? To analyze it and extract the norm developed by a judge, to know how the court applied law in cyberspace and bridged the legal the gap and the legal vacuum. At Cyjury, we depend on a FIRAC framework, and it is a globally adopted framework. FIRAC stands for Facts, Issue, Rule, Application, Conclusion. Facts. What happened? And they must be relevant to cyberspace under the concept of cyber element. The issue. The legal question addressed by the incident and arising by the conflict. Rule. Applied laws. What law we will consult and apply regarding this conflict. Application, according to cyber jurisprudence, lies in the court's reasoning and logic, how the court applied this rule regarding this legal question to settle what happened. Conclusion is the outcome, and I don't mean here the outcome, the decision of the court. It is not the decision, the court to whom it ruled. Outcome here means the norm included within the court's reasoning and logic. The court here established a norm. This is the conclusion or the outcome of the FIRAC framework, and not the court decision, because conclusions are written many times in judgments as the court decided to something. No, I mean here the norm itself, the norm developed by the court itself. And honestly, FIRAC proves most practical one to analyze cyber case laws, because it simplified them to a very basic components. So FIRAC: fact, issue, rule, application, and conclusion. Does this process is an ultimate and absolute authority for judges? From a prima facie perspective, you might say yes. A judge must ensure that the conflict is settled to prevent denial of justice. However, the job of the courts as digital norm setters and innovators are not absolute. They must comply with the basics of tech ethics and justice fundamentals. Their interpretations also must comply with them, and they're not absolute and unlimited in interpretation of legal rules, because all of us know each legal rule has an objective. So when a judge interprets this legal rule and reconceptualize its structure and meaning to fit with cyberspace conflict, the judge must comply with justice fundamentals and ethical and policy implications. So he is not totally free to invent a norm whatever he wants. He must comply with them, and as I said earlier, under the judicial supervision mechanism. Although gaps in cyber jurisprudence caused by the absence of inter-jurisdiction connectivity is a global challenge, and it should be, and its eradication must be a global motivation to contribute to cyber jurisprudence individually or even through establishments, collaborative establishment like Cyjury, because cyber jurisprudence is a new and a novel emerging branch. It is still under construction and constituting. So it has gaps. It has its own gaps, and these gaps is caused mainly by the lack of inter-jurisdiction connectivity. So collaborative initiatives like Cyjury focusing on gathering professionals, judges, law professors from several jurisdictions to create this connectivity and to create like a guidance lighthouse for courts along the world to follow its approach regarding eradicating legal vacuum in cyberspace. I have brought here some courts judgments, and mainly from the United States, to reflect how courts applied laws or reinterpreted national laws to settle a cyber dispute. And this is a brief, in fact. Okay, and I will speak of them now. In the case of United States versus Carter, the court has introduced a definition of cybercrime, introducing carrying a digitalized interpretations of traditional crime bureaus, the actus reus and the mens rea. The actus reus is the act, the criminal act. The mens rea is the intent of the criminal. Thus, the court reflects a judicial trend of digitalization. And in the world now, we are all humans have something like a digitalization mania. We all love to digitalize everything. So, in this judgment, the court has digitalized a traditional legal norm, which is crime, and the pillars of the crime. It introduced a digitalized definition of crime, which is the definition of cybercrime. In United States versus Riddick, the court adopted a technological method based on the hash value as evidence to provide a high degree of certainty in determining accountability and showcases the judiciary progressive integration of technology. In this case, in brief, this is a child and online distribution of child pornography conflict, cybercrime committed by an American citizen. And when the court inspected the online material, they found that they carry a unique hash value. Hash value is a digital number of each file. This, if any content that has been or has inflicted a very small change, this hash value changes also. So it means that the evidence has changed, and by virtue, it is not admitted as evidence. This is in brief what is hash value. In this context, the court noted that the hash value of the online distributed materials typically aligns with the hash value of the content stored and found on the defendant's laptop. So, two files, one online and one offline, having one hash value, the court established a direct accountability from between the defendant and the online distributed material. So here the court reflects an innovative judicial approach to establish accountability and a certain link between the online distributed material and the material possessed by the criminal on his laptop or on his devices, electronic devices. And it was the first time, in fact, to utilize hash value in criminal courts. In Carroll versus Macy, and this is a civil law, cyber civil law. Okay, this is the cyber civil law litigation. Okay, are you with me all? Okay, I will continue. The court considered data theft, data theft litigation, an injury in fact, and applied tort law. So this litigation wasn't on the data theft itself, the data theft incident itself. It was a compensation. It was on a compensation for this data theft. So it is a civil cyber case law. The court considered the incident an injury in fact, and this is civil law, a tort law terminology, and hence applied tort law and negligence theory to approve the plaintiff's compensation, reflecting a court's a judicial conceptualization of traditional legal norms in civil and tort law. So here there is a civil cyber case law. Okay. If anyone opens the mic, can we just close it? Because it is echoing here. Okay. In the case of console transaction processing versus tapestry, this is an intellectual property cyber case law. The court implies the fact that the presumption of validity applies to all patents, even in cyberspace and AI-generated artwork, and any party contesting patent, patent eligibility must provide compelling evidence that the patent indeed covers ineligible subject matter, reflecting a compliance with justice fundamentals. In this IP cyber case laws, the court here applied traditional law of evidence integrity and the justice fundamentals that the patent subject matter itself must be proven to be under legal protection. You can't contest or seek compensation for something which is not eligible as a subject matter for compensation. And this is something related to justice fundamentals and compliance and ethical compliance we discussed before. In the case of Betel versus Facebook, and it was one of the first case laws regarding processing of humans' biometric data when you upload a picture, in this time to Facebook, its servers and algorithms automatically analyzes your picture and process your biometric data and start to create patterns for them. So this litigation was about unconsensual processing of users' biometric data for security reasons. Because here the plaintiff here has sued Facebook for compensation because they didn't ask him for his consent on processing data. So on all online platforms now, when you start using it, you take a term, accept terms and conditions of agreements, and all agreements now include a clear clause that discloses that you provide a clear and explicit consent of processing your data uploaded to the platform. So in this litigation, the court considered that unconsensual processing of users' biometric data, even if for security reasons, is unlawful. Even if for national security concerns, national security concerns don't justify processing biometric data of internet users, of the platform users. They must provide clear and explicit consent, which is included now explicitly in all agreements when you sign up for any online platform. This reflected a judicial prioritization of human rights. In cyberspace, judges always prioritize human rights rather than other considerations like national security ones. And this case is clear in reflecting this judicial consideration. With the end now of this lecture, of this my presentation, if anyone wanna share this activity, I would ask him to choose one cyber case law, and from my part, I suggest, as we give this lecture in Pakistan, I suggest you choose one from Pakistan jurisdiction and analyze it using hierarchy mechanism and reflect on its impact on the discussion question we said earlier. Should courts invent cyber legal norms? And write a case law commentary and just send it to me to discuss it in email with you. And this is the activity of this presentation. I suggest it is a voluntary. If anyone wants to share it, okay with me. This is the end of presentation, and